morning, good afternoon. I guess good afternoon for everybody. My name is Caroline Gim, and I'm with the AREAA Default Task Force. We are doing a fantastic presentation today with some of the best attorneys around to talk about some of the changes in the foreclosure and eviction laws in regards to the COVID crisis and some of the temporary moratoriums that are out there, whether they're government mandated or client guidelines. It's hard to keep track of all of the changes that are out there right now. So we asked a few of the experts from across the country to come and join us and share with us some of our updates and to let us know what in the heck is going on. So I think now I'll be able to share my screen. Switch over. Oh, hold on for 1 second. I can't find the screen that I need. There we go. Okay. Can you guys confirm if you can see my PowerPoint presentation?
Confirmed.
Yes? Okay. All right. So some of today's speakers, we've got Ari Miller, who is a managing partner for Choice Legal Group and has been with that firm since 2009. He specializes in the area of foreclosures. Ari is a member of the Florida Bar since 2005 and also a member of the U.S. District Court for Southern District of Florida. Ari graduated with honors from the University of Florida in 2001 with a Bachelor of Arts degree. He graduated cum laude from the University of Florida Levin College of Law in December of 2004. You know what? I apologize because I've got people on top of the writing here. So if I miss a word, I apologize in advance. But while in law school, Ari was a member of the Florida Blue Key, and he was vice chancellor of the Honor Court. He has practice experience in the areas of landlord-tenant, real estate, homeowner and condo association law, consumer fraud, civil rights, employment discrimination, disability law, and general civil litigation. Ari is licensed in Florida. And Ari, can you correct me, what other states are you licensed in?
Yep, I'm only licensed in Florida, but the firm is in Florida and Texas.
Okay, fantastic. Oops. And next up, we have Beth Kirkshank. Beth was born in Sumter, South Carolina on Shaw Air Force Base. She comes from a large military family, and her parents instilled a lifetime value, lifetime of, I'm sorry, I have to get rid of these, okay. A lifetime of values and work ethic. She was raised in Alexandria, Virginia, but returned to her native South Carolina to attend Clemson University. In 1994, she obtained a bachelor's degree in political science, and she obtained her JD in 2002 from Georgia State University of Law while she worked full-time. Not only is she a managing partner and mother of 2 children, Grayson, who's 2, and Madison, who's 10 months, she has been a member of the real estate and legal community for over 20 years. She opened her own law firm in 2013, and since then has branched out to practice in Florida and Tennessee, as well as Georgia. Her firm is also very active in Mississippi, so she handles hundreds of evictions and foreclosures each month across all 4 states. She prides herself on staying on top of the relevant legal issues across the Southeast. Beth, will you wave, please, and say hello?
Hello.
There you go. Next up, we have Greg Wallach. Greg is a senior associate at Aldridge Kite, and he's represented institutional and individual creditors in foreclosure litigation and related landlord-tenant matters for almost a decade. He practices law in Florida, Georgia, New Jersey, New York, Pennsylvania, and Tennessee. Greg has received his undergraduate degree from Rutgers University and his JD from Florida International University College of Law. He currently resides in Atlanta, Georgia, and just before he was a practicing lawyer, he's got a really interesting background. He was a television director. Greg, say hello.
How you doing, everyone?
There you go. Next, we have Josh Eppling, and he's an attorney with Paget Law Group. He serves as the firm's supervising attorney of Ohio. Josh's practice is primarily focused on foreclosure, loss mitigation, bankruptcy, evictions, and title claim and curative litigation. Josh is results-oriented with over 13 years of legal experience in the default servicing industry. He takes great pride in his ability to effectively communicate with clients, as well as his aggressive yet sound thinking approach to file movement. Josh is licensed in Ohio and Kentucky. He's been practicing law since 2002. He's a graduate of the University of Dayton School of Law, where he earned his JD, and he also holds a BBA from Marshall University. Josh, say hello, please.
Hi, everybody.
Josh, what is a BBA, by the way?
Business administration, bachelor's in business administration.
Oh, fancy, fancy. All right, and last but not least, we've got Will Jarrell. Will is a senior associate with Aldridge Pite. He represents financial institutions in post-foreclosure eviction actions. He serves as the attorney of record for all evictions filed by his office in California and Texas. Throughout his career, he has represented numerous clients across a diverse range of practice areas, including civil litigation, consumer and debtor representation, evictions, and criminal defense. Will has obtained his law degree from California Western Law School of Law in San Diego, California in 2002, and he's licensed in California, Oregon, Texas, and Washington. Will, say hello.
Good afternoon, everyone.
All right, fantastic. So let's just go ahead and get started. We have a lot of material to cover, and I'm very adamant about finishing us up on time. So what we are going to do is go over some of the topics that we had planned in advance, and we're going to go ahead and collect all of the questions from the audience and then go over those at the end, if that's okay. Feel free to type in a question or a comment anytime, but it may not be addressed until after the presentation portion is over, okay? So let's talk first about what's the timeline look like, guys, since March? There have been so many things going on. I mean, I can't even keep it straight. Ari, what's like a good, just condensed version of what's been going on since March in terms of foreclosures?
Next to nothing, if that was a short summary. But so, I'll be specific to Florida and a little general. Obviously, we know, March, what was it, 26 or so hit, and we got the CARES Act, which put immediate halt on anything government-backed, HUD, GSEs, Fannie, Freddie, and then so that left. What we could proceed with would be vacants and privates that we're allowing, which was very few and far between. What we learned is most of our clients did not trust their data, what they got on vacancy. So while maybe in my system I showed, maybe an upward of 10% plus as vacant files, and I did a little testing and sampling across all of Florida, that didn't hold true as to what our clients were showing as vacant. And what I learned to find is that they didn't really trust the tenant inspections that they were getting. So unless they really got very valid data that they were able to determine, everything remained on hold regardless, right? So now as it relates to Florida, soon after the CARES Act was established, Governor DeSantis put in a very strict order in Florida that shut down the entire court system to foreclosures or evictions, regardless across the board. There was no exception as for vacancy, right? So private, vacant, occupied, government-backed, doesn't matter, all within the purview of the order. And that was the case for a very long time. The order lasted every 30 days, and traditionally about 8:30 at night before the midnight expiration, Governor DeSantis would issue an order extending it. Now, the good news is that order changed as of the 1st of this month. It was set to expire on the 1st, but a couple days before that, the governor entered a new order extending and amending his previous order. So now what the new order allows us to do is basically you could draw a line in the sand, pre-virus and post-virus. Anything that's pre-virus was the cause of the default for the most part. We are free to proceed as much and go to the conclusion. Now, what they said on post-virus defaults, anything that was caused pretty much by the virus, those are the files where we could still proceed. We could go to first legal, we could go to judgment, we could even go to sale, and some arguments can be made that we just can't take the final step for a foreclosure or eviction. So as it relates to foreclosure, we just can't go to sale, or most likely just can't get certificate of title issued. on anything that's post-virus. But what does that mean? Taking it all in context, we're not proceeding on anything that's been post-virus defaults. We're a good year away from ever trying to get to sale on a post-virus default. So that order is really immaterial to what we are going through and what we have to deal with. The courts now in Florida are wide open. So Texas was wide open too. So we're really just looking at, what do our clients allow us to proceed with? And at this time, it's been very few and far between. But now we are starting to see, at least in Florida, vacant files. Texas have been vacant files. And we just saw our first private investors and some of the private investors starting to lift their own individual moratoriums. So we're starting to see that lift. I had 1 or 2 private investors this week take the holds off. So we're starting to see some movement, but really in Florida, next to nothing at all since March. Texas only vacant files, and now a little bit of lift since then.
Okay. Now, how much of the, if it's not mandated by either the state or the federal government, if your clients have some kind of issues, like how much of it is them telling you what to do versus you advising them, do this or don't do this?
It's mostly them advising us that we can't do anything. It's very little us saying that we can or we shouldn't. Certainly if it's, sometimes obviously, we have some clients that want to go as far as they can and do as much as they can. But we also have to keep in mind that we kind of serve 2 masters. We have the investor that we also have to be held accountable to, and our client, the servicer. So sometimes we're caught in the middle and making sure they understand that, we got to play both sides, and we got to ensure we're also protecting the client from a potential violation that they might find themselves in. But for the most part, it's just, the client saying that we can't proceed on anything, and taking it to such, a very conservative approach where, the CARES Act and moratorium says, you can't do certain things. You can't get judgment entered. You can't get sale, go to sale, but it allows for interim steps to be achieved. However, most of our clients don't even want us to take those interim steps. So while we could be resolving some of the issues and be able to have a quick timeline to sale after the moratorium makes sense, very few and far between are actually letting us do those interim steps.
And I don't know if this is a question for you, because I saw on your bio that you do a lot of homeowners associations. Are HOAs in a position to do any foreclosures? If people are behind
HOAs was in a past life where I represented them a decade ago plus. Since then, I've been battling with them. But there's, to my knowledge, I don't see anything that is stopping them in any of the laws that have passed or the Florida order itself that would prevent them from proceeding at least on a default that took place prior to the virus.
Okay, but anything that's defaulted since then, it's just too bad, so sad. You're going to have to wait on it for
the most part. I mean, there's some, you could still proceed. You just can't go to sell or the final CT or the final portion of the eviction. So you can proceed on some of those if anybody would let us.
When are the GSEs saying that they're going to start foreclosures again?
So I've heard it from enough very high up sources in both Fannie, Freddie, HUD to have come to the conclusion that we're in this until December. There's going to be an extension to November 30th is what all the intel that I have is saying.
But again, that's only for foreclosures that would be a result of people not making payments starting March of 2020.
Well, yeah. Again, that'll go back to what the moratoriums. You got to separate the CARES Act from the moratoriums and what any state's doing. But the majority of our files will be following what HUD, Fannie, and Freddie has laid out. And basically, if they're based on impact from the borrower, and all the borrower really has to show is there's been some impact, and they're going to be on a forbearance if they want it, or we really, they didn't draw a line in the sand like we were hoping that they would, where they said, a post default, no, but a pre-virus default, you can proceed. They didn't really draw that line. There is, I've heard a couple people that I know some of the investors or some of the people within the GSEs, that's what they were arguing for in the hope for the next extension and the last extension. But, it's very political, and it's really above anyone within an organization. And we're looking at FHA, FA, and with the political landscape, they're just going to not let anyone get kicked out of their house right now. Now they should let us proceed to the point where, in Florida and judicial states, we're looking at what, a year-long process, right? So, I like the theory of just don't proceed to the end and allow us to proceed to the now, especially on pre-virus defaults. But as of right now, the moratorium is just, if it's occupied, it doesn't matter. We can't do anything.
Okay. And you did mention that. Let's go back to the, because in the beginning you started talking about vacancies. Is the exception to the foreclosure rules, if the house is vacant, they could be theoretically foreclosing, but some of the clients now are starting to hesitate on that, and that in Florida they said it doesn't matter. We don't care if it's vacant or not.
Yep. So you're right. Originally in Florida, it doesn't matter. You can't proceed on anything. Doesn't matter vacancy or not.
Okay.
But, vacancy was the big ticket and is the big ticket to GSEs and HUD, right? That's where they say that's where they draw the line. If it's vacant, you can proceed. If it doesn't, originally, I believe there was some language in one of them regarding whether it was owner occupied or if it was a tenant. Then the protections extended to anyone that's occupied. It doesn't matter who's in there. If somebody's in there, they're not going to let us proceed. So vacancy was really the one, line in the sand that they drew. And just unfortunately, even though, I had evidence that it was vacant, the client even had evidence, unless it passed this very stringent test where they were 100% certain that it was vacant, they weren't releasing it from home.
Okay. And Beth, tell us a little bit about the areas that you're covering, the states that you're in, like anything different that you've been noticing? Any other trends?
I'll tell you, in the other 3 states that I'm in, Georgia and Tennessee and Mississippi, they're all non-judicial. And so the moratoriums didn't actually affect it. There was nothing that came out in any of those 3 states other than the CARES Act. So let's, distinguish those 2 that said that you can't proceed with a foreclosure. The issue became all of the stay-at-home orders and all of the orders that said you can't gather more than, say, 10 people. So although there was nothing that said the foreclosures couldn't go through, there were a lot of arguments as to whether or not that would be what they call chilling the bid. So if you only had 10 people show up, were you really auctioning it off proper? I will tell you that, go ahead, I'm sorry.
No, that's interesting. I hadn't thought of that. So they think that's considered chilling the bid. I don't know if they've moved to online auctions that way so that they can say it's a free forum for anyone to come buy it. But the thought that they wouldn't hold an auction because enough bidders were not in at the auction to be present and provide a fair value, that's interesting.
Well, we had one county, particularly here in Georgia, where the sheriff came out, and although they were, we call it crying the sale when they read the notice, the sheriff came out and said, nobody can be here. And so that stopped everything in that particular county. The people that were crying the auctions were actually able to do a couple that month. I will tell you that most of my clients stopped till about July anyway, but they absolutely had the right to go through with a foreclosure. And in fact, Tennessee, for example, you can postpone the sale for up to a year once you advertise it first. So I had some that were going on during that time. And so we went and announced that we were postponing because you still have to announce it. But the moratoriums didn't specifically, at least in my those three states, pause any of the foreclosures, and other than the GSEs, of course, under the CARES Act. And so they continued to move forward. I do focus a lot more, just to give some context, a lot more with private lenders. So most of my clients, I'm not working with a lot of the GSEs. I'm working primarily with private set lenders, as well as lenders that are doing construction or lending to investors.
Okay. Now, how does that affect things? Actually, let's go back. Can you tell us a little bit about the CARES Act and what the CARES Act said about foreclosures and whether or not foreclosures could be initiated and completed?
Well, I think AREAA addressed a lot of that with the GSE is saying, pre-COVID, those were all put on pause. with the states and then the CARES Act as well. And they have said, you can't do anything right now. And I believe that, like Ari said, even if you could proceed, a lot of the servicers are pulling back and saying that you can't. But the CARES Act has said, we're going to pause. You can't file your foreclosures on anything that is FHA, or there's a long list. It's not just FHA, Fannie Mae, and Freddie Mac. I mean, there's a list of about 12 different entities that are covered under the CARES Act. So it's not just the big ones that you think of. You wouldn't think that some of the other smaller ones would be covered, but they are. In fact, one of them is, because a lot of the companies are actually making us file additional. So, there's stuff that are programs that the Violence Against Women's Act of 1994. People don't think that might be covered, but it is. So it's important to check, even if you do get that referral on the ones that were covered under the CARES Act, to check to make sure that property is not located or protected under that act.
Okay. Now, you've got a lot of clients then, if they're doing private money and they might be fix and flippers or something like that, is there any restriction on those clients from foreclosing on a property, especially if they're mid-construction and not occupied?
Well, for example, in Florida, let's just go back to that one. In Georgia, we don't have any restrictions. We're moving forward.
Okay.
If it's, on all mine, Georgia, Mississippi, and Tennessee. In Florida, even if it's a private lender, if it's occupied right now, the way the governor's order reads, and it is vague, and I'm pretty sure it is vague for a reason, it basically says anybody that is financially affected by COVID. And it goes on to define it, loss of job, loss of income, and then a general financially affected. Of course, it does not give any, does not explain, what documents you have to provide. So there's a lot going on right now. And this is both foreclosures and evictions, is to, is it a defense? Who has the burden of proving it? And to be quite honest, more on the eviction side, I've seen different judges, even in the same county, read the order differently.
Yeah, and just to piggyback off of that, we've certainly seen across the board judges, some of them putting the onus on the bank to prove the financial hardship was not a result of the virus. Others are requiring it to be affirmative action on behalf of the borrower, saying and showing with evidence that it was a result of it. But if you think about it, so, Florida, certainly until the governor's order was amended, we couldn't proceed on any of those commercial paper, fix and flip, anything like that. But since then, it goes back to when did the borrower default? So, again, if it was a pre-virus default, there's really no argument to be made that we couldn't proceed. Post-virus default, we can still proceed. We just can't go to the end. So, we can be moving those in a year from now when we'd be getting to the point where we're, getting to CT. I'm not too worried about this order still being in place.
Okay. All right. Josh, tell us what's going on in Ohio specifically. What's going on with the foreclosures there?
Sure. And here in Ohio, it's fairly similar to what's going on in Florida. Here, our Supreme Court issued a statewide tolling order that was signed off on back in March. It immediately took retroactive effect back to the beginning of March. And actually, it just expired on July 30th. Now, what the tolling order essentially did was extend all filing deadlines, response deadlines, statutes of limitation out to the 30th of July. As of today, there's been no extension of that tolling order. Now, the very interesting thing about the tolling order itself is that it actually reserved it allowed each county to still set its own deadlines, to still set its own calendars as it saw fit. So what we've essentially run into here is there are 88 counties in Ohio, which we practice in all of. It's essentially 88 different sets of rules that we need to become familiar with and make sure we're complying with, as far as whether we're able to file, not able to file, whether we're able to proceed, not able to proceed. And that's with regard, obviously, to files where we can proceed that aren't affected by the CARES Act and the various moratoriums and whatnot. One really interesting thing that's going on in Ohio is that we have it's recommended by our Supreme Court here that a foreclosure matter be completed within 1 year. And so what we're seeing in a lot of our cases now is that the tolling order is expired. And even while the tolling order is in effect, courts are still setting proceed or dismiss deadlines for us to comply with, because the courts, they want to keep their cases moving. They want to keep their dockets moving. And the closer we get to elections, judges have to turn their active files list, and so they're wanting these things to move. So that's really, the biggest problem we're running into. And, we've tried to come up with various, different creative ways to address those proceed or dismiss deadlines when those are issued, especially, in the FHA files or occupied files where we can't proceed. We've been filing a lot of motions to place the court or to place the case on the inactive docket. So it essentially gets it off the judge's active docket list that it has to turn into the Supreme Court, but we're still able to save the case. Some courts are allowing that and some courts aren't, but it's created an extremely interesting dynamic in Ohio where the courts want the cases, by and large, a lot of them want the cases to move, but we can't. So that's the main issue and the most difficult issue we're dealing with in Ohio at this time as it relates to everything that's going on.
So they've got 1 year from the time of filing the notice of default to completing the foreclosure. And right now we've got this, everything's on pause, and it has been on pause for, 5 months. But that thing is not on pause. And so the banks have to get creative with how they're going to get around that 1 year, and they're pushing it along. Have any of those expired? Anything that started last year between March and August that have expired? And
oh, absolutely. I mean, we've had absolutely, and that's a great question. And they have expired. And it's basically we're handling them on a county by county basis. Some courts have no problem staying the case, and are not really too concerned about the tolling, the 1 year recommendation that the Supreme Court has offered, and other ones are not. And so, in those types of situations, we have to try and be more creative and make sure we can do everything that we can to save the file.
Wow. Now, correct me if I'm wrong, but back in maybe about 10 years ago, I think there were certain cities in Ohio that were pretty concerned with neighborhood blight, and they went as far as like demoing properties and then like billing people. And I don't know if it was because of that or in conjunction with that, a lot of cities had these foreclosure registrations, and banks were being fined if they weren't registering a property as soon as foreclosure was filed. Well, now that we can't even file a foreclosure on things that are going delinquent after March, what's going on with that kind of stuff? And our city's still being like really bullish and kind of bullying people around and saying, hey, you got to maintain this property, and if it's going to be abandoned, we're going to tear this down for you, and then we're going to charge you for it.
That's a great question. And that's absolutely correct. There's a specific county that jumps to my mind where that was a big issue. The good thing about the current situation is, we've not really had any kind of any of those things happening ever since March, basically. So that's a good thing. We haven't had any of the the property registration issues where if it's fallen into blight and we get a demo order and have to defend that or proceed with the case or file our case. We haven't run into that, knock on wood, since this has all started.
Right.
But that's a great question.
Okay. All right. Fantastic. Now, Greg and Will, I am actually going to change over my screen to something that was shared by your firm. If you guys wouldn't mind going over it, we're going to go from the foreclosures over to the eviction side of things. Let me see if I can get my screen to change over. The problem is I have too many things open on my computer. but I can't see it.
Well, if you want, I can just start talking
You
about
can
what's
start
happening.
talking about it while I pull it up, if you wouldn't
Sure.
mind. Yeah, thanks, Greg. Appreciate it.
So Will and I, we're with Aldrich Pite, and we work the evictions for our firm, East Coast and West Coast. But what we're seeing on both coasts that they have in common is what some of the other people had mentioned. I think Elizabeth mentioned that a lot of these orders that come out, there's a lack of clarity in them. I think Ari mentioned it as well. They're written very vague, possibly to give the politicians and the judges some kind of protection. And evictions is where the rubber meets the road. So even when foreclosures start rolling in and pick up, you're still going to get caught in the roadblock with poorly crafted eviction moratoriums that allow, basically each jurisdiction to interpret it how best they see fit. I practice evictions. I'm pretty active in all my states. I'm seeing in Florida especially, and I think Ari will confirm this, that each judge is interpreting it differently, the different moratoriums, and they're asking for memos as to how they can proceed. And it's a bit frustrating for us and for the client that that's going on. So what we're trying to do is really push alternative methods to get in. I think that clients need to look a little closer at their personal property situations. If the property is vacant, possibly taking alternate routes that don't require a court order to get rid of the personal property, as well as filing in different jurisdictions and different methods. For example, in New York, the housing courts aren't really moving at all. A new order issued yesterday that I can go into in detail, but just for now, on a high end, in New York, since the Supreme Courts are moving forward, you can file for your evictions in Supreme Court. But you'd have to file a straight eviction in Supreme Court rather than what is normally the case in Supreme Court, and that would be moving for an order of compliance in the foreclosure case. Why? Because the foreclosure cases are stayed. So there's a lot of different back and forth. Sometimes you can rely on, you can look to the housing codes if there's some illegality going on in the property, or other code violations that make it a dangerous situation on the property. Then those are other avenues that you can pursue to try to get the folks out and get yourself possession of the property. Will, you have anything?
I can speak to one solution that we've been encouraging our clients to strongly consider is cash for keys agreements, especially in the state of California, which is where I primarily practice. And that is because there is an emergency rule that was put in place in early April of this year, shortly after the pandemic hit. And it came from the court system, the Judicial Council of California. And under that rule, courts are prohibited from issuing summons in eviction cases. So with the exception of those cases where there may be a threat to public health or safety, we are unable to file any new cases while the rule is in place. Furthermore, the rule prohibits us from requesting entry of default or obtaining a default judgment. And it also delays the time to go to trial. So generally prior to the pandemic, we could get a trial date within 20 days upon request. Under the new rule, all trials are being set out at least 60 days. So given the fact that we can't file new cases, we can't default defendants who are not participating in the cases, and we can't get a trial date anytime soon. And even if we get the trial date and we get judgment, we're not going to have a writ while the rule's in place. We're kind of at a standstill with respect to our cases in California. And so cash for key agreements are something we're strongly encouraging to make the offer and see, one, if we can get a response on those offers and maybe build from that point on. Obviously, if the occupants are willing to accept cash for keys and you can come to an agreement and they voluntarily vacate, that's always the best resolution to any eviction action. And that's basically one of the only means available. With respect to the exception carved out for evictions related to threats to public health or safety, those are very difficult to accomplish because when you file the case in California, the court is going to set an evidentiary hearing, and they're going to require the party filing the case to bring in some sort of evidence showing how there is an ongoing threat to health or safety. And in my experience, those cases don't get very far. You get to the evidentiary hearing, unless you have something very concrete, the court's not going to allow you to file that case. So Greg and I are really trying to encourage our clients to think outside the box. The court is not our friend right now. It's not a system that we're able to use. So we encourage our clients to try to broach settlement with these occupants and see where we can go from there.
If I can add to that, in addition to settlements for cash for keys, if the property is just only has personal property in them, we're also trying to get cash for personal property release, which we really never have tried to do. Some of these folks don't have a good opinion of the banks anymore and the lenders for obvious reasons. But you know what? If you could sweeten the pot a little bit, that they can release whatever personal properties left without having us to go back to court for relief, that would be a win for everyone, especially now in light of what we're dealing with. But one other problem that we're facing is that the GSEs, many of the servicers, don't want us approaching the defendants, the occupants, asking if they're interested in cash for keys. They don't want to have the appearance of trying to somehow force people out, and they're very concerned about that. So what we've done is, in some cases, when we're approached, then a lot of the servicers will then entertain cash for keys negotiations. But otherwise, they don't want us making any efforts. When there is a cash for keys agreement reached, though, we have addendums that we like to add to them that provide some COVID protections in general.
One important.
Now,
could I just chime in one thing that I think we missed in kind of like the timeline, how the CARES Act and the moratoriums are playing into each other. So we kind of know that, the CARES Act was put in place and the government enterprises put in their own moratoriums, and the CARES Act pretty much has expired for the most part, right? The eviction portion was expired on July 25th, I believe. The foreclosure section, all they did initially was said, okay, no, these are halted for 60 days and allowed for additional 4 30 days extensions that weren't even needed because the government enterprises and HUD, they all put it in place themselves. But one thing that we didn't mention is what President Trump enacted with the executive order, trying to somewhat extend the CARES Act. But I think it's important that we just touch on that for a second, that it really didn't do anything. The CARES Act was already expired. This didn't extend the CARES Act. All it really did was put onus on a couple agencies to investigate if there are any funds to put forth towards preventing foreclosure and evictions to the extent that an eviction or foreclosure would lead to the spread of a virus, and I believe even from one state to another, which is very unlikely. So, just keep in mind that the order that was just entered by the president didn't, in fact, extend any evictions or didn't put any additional deadlines or prevent us from doing anything. It's all at this point really up to the individual investors and HUD, Fannie, and Freddie. Of course, who knows what will be in any bill that passes by Congress in the future if they actually get their act together and get through another stimulus package. And we've seen the House bill that was passed months ago that included a full year-long ban on evictions and foreclosures, similar to the one they tried to do in California that I believe has reared up again after it died on the vine. But that is something to keep aware of and keep track of, not only what we're seeing from the investors and Fannie and Freddie and HUD, and certainly what the president was doing was making sure that his voice was heard to Fannie, Freddie, and HUD, that he wants the moratoriums to be extended, and then we know that that's happening anyway. But certainly keep your focus on what gets in any sort of bill that passes the Senate and then the House, because we might see additional length of time over what the government enterprises were already contemplating doing.
We're going to see it out in New York. There's 19 pending bills before the legislature that would extend evictions somehow, and 5 local New York ordinances are pending as well, and they could last up to a year.
For Ohio,
so Greg, I mean, you're in New York and New Jersey and Pennsylvania, which even before March were known throughout our REO industry as problematic areas to do evictions. Did this make it worse, or is it about the same as before for you?
It's much worse. It's
So
much
it can
worse.
get worse. Okay.
One of the judges, which is the quote I use a lot, I get on these telephonic hearings. I'm inevitably the first one that's called my cases, and the judges make an announcement. A new order was just handed down. It was sitting on my desk. Shifting sands. We're all standing on shifting sands. So everyone has to be flexible in their expectations of what kind of relief they're going to get. And it's unfortunate. What Will and I have also done is we have, in situations where the judges in all these, everywhere, the judges are also kind of have some fatigue. They're not even reading the extensions in some cases. Ari mentioned the latest governor's order is not a straight extension of the moratorium. It's an extension and a revision of the moratorium. And these judges are not seeing that. I had a hearing just this morning where the judge admitted he had not read an order. He claimed he was not as familiar with it as he'd like. And, we prepare memos for these judges to help them when they have not done so. And the sheriff's departments as well we have to hold their hands and do what we can. If necessary, we'll contact the city attorney to say, you've got to call the sheriffs. They're not executing our writs. And that's what we have to do. And so, yes, it has gotten worse.
Even worse. Now, Beth,
I would say I completely.
You're in a state where it's kind of, I think the politics of Georgia, for example, is more like, okay, we want to get back to work as soon as possible. And I understand if people are saying we're not going to foreclose on people because they're falling behind on payments due to COVID. Maybe we're not going to evict people who are falling behind on their rents as a result of COVID. What's going on, though, with former homeowners that are being foreclosed on or who've been foreclosed on and are in evictions? Are they making that a challenge at all? Are they saying, well, someone is in the house and so they might suffer, period, even if they're not a tenant? If they're the former homeowner, have you been able to initiate any evictions?
Well,
Elizabeth, you want to answer?
Yeah, in Georgia, we can initiate them across the board now. Actually, in Georgia, in all 4 of my states, we can initiate the evictions. What we're seeing, though, in Georgia, at least in Georgia, is that our Supreme Court and our governor keeps extending, by the way, our public emergency, and our Supreme Court keeps doing the same. The problem is that each of our courts are then trying to figure out how to work within that order from the Supreme Court. Some of our courts have been great. They've been doing video hearings the whole time. Others courts, especially the larger ones, for example, Fulton, which is where City of Atlanta is, basically came out and said, we are not doing anything until November 2nd. They attempted to do, I think, 1 calendar by video, and it was a nightmare. And so we are trying to find ways to get them to move, because otherwise they're just sitting in there. And so we've tried to file motions for, when they answer and say, I admit. So we'll try to file motions for judgments on the pleadings. Georgia has a nice law that says that if we can't determine possession within a 2-week period, then you have to pay rent into the registry of the court. Okay, we filed those motions. The problem is we still can't get the judges to hear any of those motions. So, in some of our counties, we're able to move, we're able to get writs. We've gotten I did a lockout in Georgia 2 days ago. Then I have other sheriffs that won't do it. So there's no real guidance. I mean, I think our order says, do it to the best of your ability is the gist of it. Do what you can, but we're not going to hold you accountable. And so they can sit in there for, another 6 months because the backlog is already so bad. I think when we paused, Fulton had over 1,100 active eviction cases. And I can't even tell you the number that have been filed since then, that we're just sitting here. So if you can get somebody to do cash for keys or get somebody to move out ahead of time, I think that's going to be, the best way to get them out. And if you've got a tenant, say that's not a post foreclosure, but say in an apartment or something like that, then, if you've got anybody that's claiming repairs or you're going to have sort of any evidentiary, you can look into next year in most of our counties.
Okay.
Mississippi has been moving. Mississippi, they don't care. They've just been going and going. And to be quite honest, most of Tennessee has as well. Davidson County, their mayor has shut down the courts until September 1. So
the courts are shut down?
And
I did ask you guys about this previous to our webinar when we did some prep work, but I've been hearing from other attorneys doing, family law cases and criminal cases that the courts are shut down, but my understanding is, at least locally here, when they reopen, they're going to be doing they're giving priority to obviously like criminal cases and things like that where there's a public safety issue. What's going to happen to the ones that are, evictions? Are those all going to fall to the bottom of a pile, or is one judge going to be sitting there taking care of all of them? How's that going to look moving forward? Josh, why don't you go ahead and answer this if you can?
Sure, that's a great question. And actually, my wife is a staff attorney here for the county that I live in, so I get a little bit more some insight on how those things kind of work. But you're absolutely right. I mean, since the tolling orders expired here, all the criminal actions are taking priority. And unfortunately, the evictions, the foreclosures, those are getting pushed to the bottom. And that's it's up to the judges, the judge's discretion as to how those are going to be handled. But your analysis is exactly right, is what's going, as to what's going on, at least here in the county that I live in. Now, again,
how about Zoom? Are they going to be doing Zoom cases? Are they doing them now?
So we haven't initiated that. An order was just issued, or a recommendation. And I actually had to write it down because it just came out. Let me take a look at it really quickly here. An administrative action was just issued, which does allow any requirement and a rule of the court that a party appear in person or requiring in-person service to be waived by the court, local court, hearing panel, board, or commission. So while it doesn't specifically state that they're going to be holding these hearings via Zoom, it is essentially, my interpretation of it, at least, is that it allows it. I've personally not handled any of the Zoom hearings. I know that those are being done down in Florida from speaking with the other attorneys at our office. But as far as Ohio goes, that has not taken place, at least with me yet.
I've been handling them in Georgia,
Florida,
Florida, and Mississippi so far. Georgia, it depends on the county. And some of the counties, even though they don't specifically say you can do it, a lot of times if you file, in Georgia, if you file a motion, you can get on a Zoom. Florida's been doing phone hearings for years. So, I mean, they were just, I think, really far ahead. But we've been handling Zoom hearings for our evictions for the last, 60 days or so.
All right. Well, I want to put you on the spot because you handle California. So selfishly, I want to know about California, but I also know that California is probably one of the most headachy states right about now. We've got the CARES Act. We've got, We've got the state of California saying things. We've got different counties saying things. We've got different cities saying things. We've got judges that are just making their own laws up as they go along. What can we look forward to? Tell us some of the fun stuff you've been hearing around California, please.
Well, I don't know if there's a whole lot we can look forward to per se, but it is true. I mean, we aside from the Judicial Council rule, which I previously discussed, there are moratoriums peppered throughout the state depending on where you are, and you could have a moratorium that applies to the county that you reside in as well as the city you reside in. So it's critical, depending on where you are in the state, that you need to be aware of what moratoria apply to a given property. And it's a mess because they're not uniform. Some of the moratoriums essentially say that you can't proceed on evictions where the basis for the eviction is non-payment of rent. Some other moratoriums have that same provision, but then they also basically allow the defendants or the occupants to withhold rent for a certain period of time. Those periods of time may differ. The expiration of these moratoriums differ. Certain areas have banned residential evictions altogether. I believe the county of Alameda, as well as the city of Oakland right now, have essentially banned all evictions unless you can present evidence that allows you to fall in that public health exception. So we'll see what happens. Most of these moratoriums, for the most part, are set to expire on September 30th. But I think, as has been the theme of this panel, we are all expecting things to be extended, and to what extent they'll be extended, nobody can say. That holds true as well for the Judicial Council order, because that rule was written such that it will expire 90 days after the governor lifts the statewide state of emergency. When that will occur, who knows? A few weeks ago, we started going backwards here in California with respect to reopening the economy. Things are now starting to look a little better. Things are constantly changing day by day, week by week. So whenever the state of emergency gets lifted, then we're looking at another 90 days under the rule. But I think, as Ari sort of mentioned, there is legislation coming down the pipeline wanting to extend those protections beyond the 90 days. And I think Ari was correct. There's even something being discussed to extend the protections for a full year after the rule expires. So again, I don't know if there's much to look forward to. I think we will see the other side of this. It's just a matter of time, and who knows when, unfortunately.
And the Judicial Council thing, that's the one that is set to expire. Is it tomorrow, the 14th of August?
No, that's the rule that is actually, it doesn't expire until 90 days after the state of emergency lifts.
Okay. Yeah, there's just so much going on here. So we are now going to go over and check out what kind of questions we've got on the chats and on the question section. So if you've got a question, audience, please go ahead and type it in either the chat or the question and answer boxes. Okay. I don't know if you guys are able to answer this, but do you think that banks are going to be more likely to entertain short sales during this period when evictions are a little bit harder to do?
I think it's a good question. I think the private investors will be more aligned to be aggressive in their short sale, realizing that's a good way. When you're looking at the guidelines of Fannie, Freddie, HUD, they're very specific in what that equation looks like. So I haven't seen any guidance, and I haven't heard any chatter that they're going to change that for this situation. I think it's a good idea to do that when you factor in what's probably coming down in prices and how long it'll take. But we haven't seen that yet, except for on some privates. I would expect that to be the case.
Okay. And then Josh, I think this may be for you specifically, because the same person also asked that they said that they're in Ohio, Cuyahoga County, and they have properties that have been sitting since March with no confirmation or deed recording. So do you feel that, like in certain areas, especially maybe in Ohio, that if the evictions or foreclosures are even harder to process, that the banks would be more open to a short sale?
Absolutely, and that's a great question. Cuyahoga County is actually the county I was referring to earlier that you had asked a
Yeah.
question about. The one good thing about them is that they have done a good job of allowing us to file notices of intent to proceed on cases where we can move and request that the cases be stayed where we cannot move. And the good thing also too about Cuyahoga County, while there are, it's a fairly borrower-friendly county, but their magistrate staff is dedicated solely to the foreclosure cases. So that's a good thing, and it's allowed us to move there a little bit more where we can. But I do see the question here. Yes, I mean, the issue too with Cuyahoga County, and this question has stated that there's been no confirmation or deed recordings. Cuyahoga County actually confirms their own sales. It's the only county in our state that does that. So, unfortunately, we really don't have any control over how quickly the sale confirms, other than, a weekly follow-up with the magistrate's office or the court to say, hey, is there anything we can do? Do you need anything else for us, to cause this case to be confirmed? But yeah, it's a great question.
Okay.
I wish I had a better
and there's
answer,
a question. I don't think there are a lot of good answers here. I think it's just a lot of good information to share, because you guys are in a much better position than we are to be maintaining, just staying up to date with all of the changes to the laws. But there's so many that are happening. And I mean, I honestly think that this exact same webinar could happen in a month or in 2 months, and it would be completely different information that we're going over. Kind of going back to another question that we've got here, and they ask about cash for keys. In some cases, the occupants or the tenants, they are asking for, obscene amounts or ridiculous amounts of money, or for cash for keys. I mean, I don't see why these occupants wouldn't just wait until the very, 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 very last moment, and then once evictions are on the table again, then decide, oh, well, now it's been 12 months and now we're open to cash for keys, and we're going to need a lot of money and we're going to need some time to move out. Because, and same for short sales, just thinking about that, like, why would somebody want to do a short sale now knowing that they're not going to get foreclosed on for the near future? Why not wait until they're closer to that impending foreclosure sale and then decide they want to cooperate with the banks? Have any of you guys been talking to your clients about this? I mean, I know that encouraging cash for keys has always been, the ideal. Even before COVID, it's the easiest way to get people out.
Well, Will and I have been discussing it because just like a lot of businesses are taking a downturn, a lot of defense counsel are taking a big downturn. And so they are desperate to get their revenues going, especially when their model is based on attending hearings. So that's not happening. So I think a reasonable cash for keys offer we're finding are being accepted because their attorneys are in effect lobbying them to take the money so that they themselves can get paid. It's unfortunately it's a bit unseemly. I think there's a conflict there, but at the same time, they're doing it. So you'd be surprised, even in situations where someone had, prior to the COVID, had made a huge request for fees, for cash to vacate, they're accepting a much smaller relocation incentive now because their attorney is pushing it so hard.
Okay.
And it
Okay,
never
good
hurts to just engage in the initial discussion first to see where the occupants land and what they're asking for. Obviously, if it's something unreasonable, then you might not get very far in the negotiation. But considering the economic downturn that we're in and the number of people who have lost work and are looking for income, it's just a smart option to throw out the cash for keys option. And maybe it begins a discussion that gets you somewhere where both parties can agree.
Okay. We've got one question on the chat asking the panelists, do you anticipate a tremendous uptick in foreclosures in 2021?
Yep. So I can tackle what I see going forward for the next year or two, and I also see a similar chat question from MK about whether we think loan mods will be a large scale option going forward, and obviously that ties heavily into the forecast for the next couple of years, right? So here's how I see things playing out. Again, you're kind of drawing a line in the sand between pre-virus and post-virus defaults and when those start trickling in. So let's say we do get the extension till December on the current moratorium. You'll see a little trickle between now and then from the privates and the vacants. But let's say that opens up. I think you'll see influx in that December, January timeframe of foreclosure starts and sales that have been pumped up, right? So we'll get the sales going. So you'll see the volume of active files starting to proceed at that time. We'll see an uptick in foreclosure starts in that beginning couple months. It's going to take probably most of our clients 30, 60 days. Remember, defaults that occurred in November, right? There's a 120-day rule that they can't refer out to us until that 120 days. So the defaults that the referrals law firms were getting in March when the moratorium started were from defaults in November, right? And then December, January, those were what we would have been seeing in April and May, and those are what all stopped. So draw a line in the sand, everything that defaulted prior to March, those would have been referred during this moratorium now that have all kind of pepped up, but most of our clients weren't sending out default letters, a lot of the loss mitigation letters. So there's going to be a lot of that volume, about 2 to 3 months worth of volume that would have been referred in March, April, May that didn't get referred, that are ready to come once they finish their scrubs and send them out. So look for an uptick. Still nothing big, nothing to, get too, much volume about. But you'll see an uptick in sales and referrals coming through in early 2021. Then once you get those files, you're going to see, again, draw a line in the sand of post-virus from pre-virus, the post-virus defaults, and now think about what we've learned from a forbearance standpoint. Most of the files that we have in our active inventory that were pre-virus defaults, those didn't go on a forbearance for whatever reason. The majority of those did not hit the forbearances. The forbearances, for the most part, took place on the post-virus defaults. So most of the post-virus defaults are on a forbearance. And those forbearance, under the CARES Act, gave them the 6 months, an additional 6 months. So you're looking at a year. So you're really looking at about a year from when they defaulted. Right? Most people didn't default in March or April, really May, June. Is
so it'll be a year from the official default date, which is going to be whenever this is up.
That's when I think you would start seeing some of the post-virus defaults referrals come in. Now to tie into where that plays into the loan mods, and everyone's on this forbearance, and it's very simple. The equation is simple. If you have a job at the end of forbearance, you're going to get some sort of loss mitigation option workout. If you're employed, they're going to fit it into you either through the loan mod option, the deferment option. There's so many easy options for you. Very simple. It's going to be based on employment. If you have a job, you're going to get some sort of workout. If you don't have a job, those are the ones that are going to be ending up in foreclosure. So it really comes down to a geographic, picture. It's not going to be across the country. There's going to be some areas that are going to get hit worse than others. There's some that are going to have a very similar default to what it was before. So let's say Miami. Miami's a big city that had a lot of stress on the housing market prior to the virus. It was named one of the top cities for a household debt to income ratio. And also what's tied to tourism, right? So that's going to be one of the last sectors to come back. So I expect Miami to have maybe like a double the volume of foreclosures, in a couple years out.
Sorry, we're going to have to wrap this up. It's a yes, but it's also a no, because things are going to get drawn out depending on geography and also depending on whether or not they've got a job at the end of all of this. Correct. To have other plans in place, it sounds like. Yeah. Beth, what do you think? Yes or no? The foreclosures up or down 2021?
I agree with AREAA. I think they're going to be up, but I think it's, you're going to see them more towards the middle to the end. And that's all assuming that things don't get extended, because,
right.
Get extended, then we're going to be looking at 2022.
Okay. All right. Josh, what do you think?
I think they're going to increase, echoing the same sentiments as everybody else has. The loss limit's going to be a big deal, I think, here moving forward, obviously. And the other thing is you just don't know. It just depends on what happens.
Right. So. Greg, what do you think?
I think they're going to be up, but I'm hoping that they'll be instituting separate foreclosure courts and magistrates like they did at the end of the last bubble to help out with the overflow and influx.
Yeah, the volume, sure. Will, what do you think?
I will concur with my fellow panelists. I think we're all on the same page. I think they're going up. It just is a matter of what's going to come down the pipeline and how much longer things will be delayed.
Okay, all right. Well, thank you so much, guys. This is the end of the webinar, so I hope that we were able to get a lot of good information out to our members. If this is something that the members found value in and they want, a follow-up, please just let us know. We can always schedule a follow-up or something similar to this either next month or the following month. But yeah, thank you so much to Ari, to Beth, to Josh, to Greg, to Will for giving us their time and all of their expertise. We've got one handout that we can make available to the members, and that was provided by Aldridge Pite. And if anyone else would like to provide any informational handouts to be made available, just send it on to me, and then we'll forward it on to the national group. Okay? So thank you.
Thank you, Caroline. Thank you, everyone.
Thanks, Caroline.
Thank you, everyone.
Thanks, everybody.
Have a good afternoon.
Bye-bye.